Hey guys, we are going to look at the trial that has already passed for Sean Williams. This was the attempted escape and successful escape trial. And we're a little bit behind on catching up, but we're going to look at some of the motions that Sean Williams filed himself because he represented himself pro se, and then look through the notes from the trial based on journalists who were present to see how that trial went down. He was found guilty of one of the escape charges, but not guilty of the attempted escape charge, and we're going to look and see how that played out. As a quick update on the pending trial for the CP charges and everything else, really the more serious trial, that's been pushed back to November, so that's not happening next month as scheduled. But let's hop over to the end of July. We're going to take a look at a few short motions, and the reason they're probably short is because this is Sean Williams writing these motions himself. He's pro se. This is going to help us get an insight on how he argued in the courtroom, because since it was federal, it wasn't televised, there's no recordings of it, and the transcripts weren't accessible, so no court transcriptions. So we're going to work with what we got. These were motions before trial started, but again, they will give us insight into what Williams was planning to argue to defend himself. So here, and this was filed on July 19th, just a week before trial. Motion to request funds for an expert. What does he want an expert for? Now remember, as we go through this deals with two different escapes. One is his escape when he was actually successful, and then another attempted escape because they found out there was a hole in his cell that he was like carving through or whatever, and he never actually successfully got out that time. There was just a hole found in his cell. So really the two charges relate to two separate incidents, and the grand jury indicted on both, and this is what he's fighting. So here, the defendant is trying to establish that the wall in question, this is the attempted but not successful escape, in case CR 27, is an 8-inch solid cast-in-place concrete partition wall that divides two cells, and to establish that the concrete, and it's in quotations here, allegedly removed from the wall is in fact not concrete, but a patching material, and that the patches have failed, resulting in further remedial repairs being completed by simply applying caulking to the loose material to hold it in place. 3. Also to establish that the entire facility has similar conditions at the floor joints as a result of active structural settling of the foundation slab, independently from the pylons that support the vertical walls. The result is a gap at the floor level that is filled with failing repairs, caulked together over the years. It is important to establish this information because the material in question is frequently removed by inmates from many cells to facilitate the passing of small items between cells, and that the material can be easily removed by hand by simply peeling away the flexible caulking, and further establish that the approximate 1-inch tall, quote, cold joint could in no way facilitate any type of escape, and that similar conditions exist in many of the cells. So here's an alternative for why somebody might have found a hole in the wall of the cell he was in. It could be explained for a reason other than an attempted escape. Also to establish that the, quote, 4 feet of material removed from cell 5 does not and cannot represent what may have been removed by the defendant, because any length of material up to the length of the cell can be removed by hand. Therefore, for the prosecution to state that the defendant removed all this material is misleading. In other words, once one piece of material is taken out, it acts as a keystone, allowing all of the connecting material to be very easily removed. Wherefore, the defendant is requesting a licensed building inspector or general contractor to be retained to determine the facts set forth herein. So he wants an expert to be able to talk about this process, these materials. And he signs here. And he spelled his name wrong. Well, there we go. So there is one motion, a request for funds to pay an expert witness, filed by our pro se litigant here, Sean Christopher Williams. The next day, he filed another motion. This is July 20th. Motion to collect indicated evidence from Washington County Jail. The list of items to be collected from Washington County Detention Center was provided by the defendant to his prior counsel, Mr. McAfee, on February 12th. Remember, he went through several attorneys. A more detailed description was provided via email to Mr. Bernstein, that's a different attorney, early on July 15th, despite the only time given to prepare a thorough list being over the weekend. Rather than Mr. St. John using the prepared list to collect items, he only collected the few items described by Judge Greer in his order. Greer does not know the evidence that is needed for the defendant's defense, yet that is all the evidence collected. The full list from the email is here. 1. Names of the 3 inmates that were housed in the cell on the other side of the partition wall where the material was removed from. 2. Close-up of the floor joints to show the horizontal cracks and caulking that is holding the material in place. These pics needed to be taken from several different cells to show the widespread cracking. All of the cells in C Block 7, C8, and C9 have this problem. This equals over 200 cells, so access to an open one should be available. 4. A diagram is needed of the area in question to show that it is a partition wall that is approximately 8 inches thick. 5. Pictures of the floor joint on the other side of the wall, the cell on the other side of the wall in question is needed, that show the fresh, unpainted areas in both cells to indicate that the hole did go between cells and was repaired at the same time. 6. Video of a metal key being tapped on the joint over a span of several feet. Not the area freshly repaired, but any other areas or cells. The tapping should be so that the audio indicates the hollow, detached sounds made. This is called sounding tests. 7. Identify the cell that I was moved to on the second level after the alleged incident and take photos of the floor joints in that cell as well. Photos approximately 1 feet away or video will show the existing cracks and caulking. Failed repairs will be identified with more video sounding tests from that cell. 8. Video from the jail the day the cell searches were conducted needs to be secured. I'm referring to the cell on the top level that I was moved to after the alleged incident and where the quote notes and legal docs were taken from. 9. I will also need the female CO named that searched my cell. She is possibly Mexican. She said she was from New York accent and very dark permanent bags under his eyes. She can be identified by the video of the cell search in the PC pod a week or 2 after I was moved to that cell. 10. The date of the cell search when my legal notebook was taken, and the date of the alleged incident. 11. The cell number from the alleged incident and the cell number I was moved to. 12. Lieutenant Schrader needs to be subpoenaed. And then it says 90% of the photos Mr. St. John collected were not listed and are completely irrelevant, such as toilets, beds, windows, desks, sink, door, and door windows. The result is that the defense is unprepared for trial until the list of items outlined in the email are collected. Also on the 20th, we get a slightly longer motion because we get some exhibits, we get some photos. Motion to dismiss based on spoliation of evidence. According to the Washington County Sheriff's Department report 23-43599, on July 23, 2023, the on-duty officer entered the defendant's cell, that's cell block 8, pod cell 5, on a tip and found 6 pieces of concrete that had been removed from the wall and placed back with toothpaste. And then in quotes, the concrete was approximately 4 feet in length and 3.5 inches in width. After removing the defendant from the cell and placing him in another cell in the same pod, the defendant witnessed the affected area in cell 5 being patched and repaired by a trustee approximately 1 to 2 days later. After the repairs were completed, the cell was put back into service and remained in service for the next several weeks that the defendant was housed in that pod. On July 12, 2024, a court order was issued to allow the defendant's private investigator to access the cell to collect photos. Upon arrival 2 to 3 days later, on or around July 15, 2024, it was evident that the cell 5 had been taken out of service and photos were taken of the cell that clearly shows that large areas of concrete had now been removed from all sides of the cell, and the debris had been cleaned up, leaving multiple large areas of concrete missing, much larger and in more areas than identified in the original report. Upon information and belief, a member of staff at the detention facility authorized the cell to be taken out of service and the concrete to be removed in an attempt to spoil the evidence that the court order authorized to be collected, and to attempt to exaggerate, inflate, and mislead the jury by preventing the collection of pictures that represent and show the actual area that was allegedly removed by the defendant. The defendant is now prevented from obtaining photos that reflect the true condition of the cell and associated repairs of the area and cell in question. While it may be possible, it is unlikely that the facility, a day after the order was given to allow access, unknowingly started demolition, making collection of evidence to prove the defendant was not guilty impossible, deciding to suddenly begin extensive floor repairs involving the removal of large sections of concrete in cell 5 only. If necessary for the court to be convinced this was done as an attempt to prevent the defendant from gathering needed evidence to prove his innocence, the defendant would like to identify inmates that were housed in cell 5 within the last several months and question them in regard to the timing and intent of the concrete being removed from cell 5. Wherefore, the current attempted escape charge defendant is facing as a result of the alleged removal of concrete should be dismissed on the grounds that the jail staff has interfered with a court order and purposely obstructed the defendant from collecting evidence to receive a fair trial. And he must be copying his signature over because it's always just signed Williams. So, I mean, And then we get some exhibits attached. So some photos here, which I'm assuming maybe this is to show that the debris was cleaned up. These are dated for July 15th. A gratuitous photo of the toilet. More seams. Yeah, no debris on the floor here. All caulked up. And here, this is a little dinged up right there. And this one's kind of important. I think you can see how close, and I'm assuming, I guess the same would be the same over here. But if we look over at this partition, that would presumably be the distance between the start of the wall over here and the start of the wall over here. So how far through would we need to go to reach each other if we wanted to communicate and hand things back and forth between 4 and 5? All right, and so this is from the investigator. On 7/15/24, I visited the Washington County Detention Center for the purpose of photographing Mr. Williams' cell, along with the adjacent cells. I was allowed to take my camera, my billfold, and car keys. I was not allowed to take any pens or paper to identify the pictures as they were taken. Stephen St. John, and then he signs on the 19th. Now we have an incident report from July 23rd, 2023 from a witness, Toby Briggs. So on 7/23, at 9:30 hours, Deputy Jessica Smith responded to an attempted escape at the Washington County Detention Center located at 114 West Jackson Boulevard. Inmate Williams is being housed in C8 Pod, Cell 5, due to multiple disciplinary infractions. At approximately 04:15 hours, the on-duty officer received a tip that inmate Williams had been removing concrete from the bottom of the cell wall connecting to the floor. The on-duty officer entered the cell and found 6 pieces of concrete that had been removed from the wall and placed back into the wall with toothpaste. The concrete that had been removed from the wall was approximately 4 feet in length and 3.5 inches in width. We attempted to contact the supervising deputy U.S. Marshal, Hector Dominguez, by phone and text message. Now there's a written statement here from Toby Briggs. Let's see if we can read it. On the above date and time, I, Officer Toby Briggs, was conducting a round in C8, where I received a tip that inmate Sean Williams, C8 Cell 5, was removing concrete from the bottom of the cell wall and floor. Upon entering Cell 5, I found pieces of concrete that had been removed and then placed back in place and held together with toothpaste. Removed the concrete pieces from the cell, and pictures were taken. End of statement. And then we have attached the order here from the court allowing Mr. Stephen St. John, the private investigator, to go look at the cell and take pictures, as well as an order for the Washington County Detention Center to provide Mr. St. John with the names of all the inmates who were in Mr. Williams' cell and the 2 adjacent cells on the date of this alleged attempted escape, which, according to the United States' second superseding indictment, is Sunday, July 23rd, 2023. And so there's the end of that motion from our pro se defendant. And so there were several motions like that for some type of miscellaneous relief. And then there was a motions hearing on July 22nd, and everything was denied. so there's that. After everything was denied, and I think jury is already seated, we get this motion to suppress, handwritten, filed by Sean Williams. It reads, while every opportunity and effort has been made to meet the motion deadline, it has been very challenging to prepare for trial and familiarize myself with the 400+ pages of discovery. Crossed out says I can now say that took is finished while, and then we get back to regular writing that says, and to file motions for 2 separate cases, both with deadlines within days of each other. With that said, I did not get an opportunity to file this motion after reviewing the associated discovery and would like the opportunity to file this last motion as it is of great importance to case CR-27. During review of the discovery last night, I discovered that all of the photos and photocopies, as well as the incident report, all have the same July 23rd, 2023, 11:10 timestamp. Rather than timestamps on these items, a template appears to have been used to insert the above-mentioned date into. To have taken the dozens of photos and photocopies during a 1-minute period would simply not be possible. Okay, what do you think about that argument? A binding and true timestamp is generated by the device used to take the photo or copy and cannot be simply made manually inserted as a margin template. Rather than to object to each photo or copy as it is displayed for the jury, the defendant asks that any photos, photocopies, and incident reports fabricated by the use of a template or otherwise improper and methods crossed out, certified or verifiable method, be suppressed from the jury and evidence is crossed out. These photos appear to be limited to the, quote, attempted discovery, however, may also exist within the, quote, escape discovery. And then signed by Sean Williams on July 24th, 2024. They scan the back of the page just to show that there's nothing on it. And then we also have the attached, so if you look here, we have the 1110 timestamp. These presumably are the concrete pieces recovered from the cell on the 23rd of 2023. Same thing, 1110. Then he's also noting that the statement from Toby came at 4:15, not 4:50 hours. And then it says challenge timestamp, reported 1110, taken 1110, all blank pics and copies in 1 minute, question mark, question mark. Another 1110 on the report. And then it also seems like he's questioning, who was the complainant. We have unknown, unknown, unknown. So we don't really have any notes here, but presumably that's why we're circling this. Because who can verify this stuff, right? I guess that's the argument. So that's a look, and I don't even want to say pre-trial because jury is sat for that last one that we just looked at. But in general, to sum it up, those are some kind of pre-trial motions that as a pro se defendant, Sean Williams filed. And they are pretty much denied across the board, but interesting to read and very helpful since we don't get to see in the courtroom as he makes his argument. I think those filings gave us a good idea of what he may have sounded like on the courtroom floor. Now we are going to look at some of the reporting here. So this is starting on July 22nd. Trial Tuesday, defense lawyer on what Sean Williams can expect representing himself. Defense lawyer here, Chris Bird, shares his analysis on why he thinks Judge Ronnie Greer is approaching this case the way he's approaching it, considering we have a pro se defendant. So Bird said Greer has likely been very careful through the various delays to avoid any missteps that could give Williams an opening for a successful appeal, a non-uncommon effort among defendants who represent themselves. Judge Greer knows the appellate law. He knows what the Sixth Circuit is going to do in cases like this, because this obviously wouldn't be the first time that someone's had to go pro se or has made trouble for counsel, Bird said. So, I'm certain Judge Greer has been planning for this after the first attorney was let off the case, certainly after the second, because you start to see the writing on the wall, and you start to plan for what happens if this person continues. Williams' charges this week involve an alleged attempted escape from the Washington County Detention Center last July and an escape from a prison transport van in October as he was en route to a federal hearing. Williams has filed numerous motions within the past week and claimed in one that he was forced to proceed pro se, represent himself, on July 11th. Bird said that claim is among a number of potential moves Williams may quickly learn don't work when normal procedural rules are being enforced. I'm sure Mr. Williams will be instructed not to tell the jury that he was forced to represent himself or things of that nature. Rules like that and many others are a major reason the Constitution is interpreted to allow appointed counsel even for defendants who can't afford a lawyer. We know where to look for things if we have a question, and the average person out there is just simply not going to know those things, not only knowing what the law is you're charged with, the nuances of that, but how to cross-examine, what are the rules of evidence, what are the rules of procedure. All these things you have to know going in as a pro se defendant is like trying to play in the Super Bowl without knowing the rules of football. And Bird talks about why it gets to this point. Bird said defendants who end up representing themselves may have an inflated opinion of their ability to navigate the system. In the case of a person like Mr. Williams, who has had 4 very experienced, very capable attorneys appointed to him, when you keep running into the same problem with a person like that, clearly they think they know better than the attorneys. Bird's seen defendants who are in denial about how evidence will be used against them, or just don't like the answers they're getting from attorneys. Pro se defendants can get in trouble from a variety of ways, including asking leading questions, trying to testify from the podium, or bringing up things that haven't been brought out in evidence. Hey, there's some attorneys that do that too. They don't understand that you can't do that there is a method by which you have to do direct examination and cross-examination. There's procedural constraints on that. There are strategic constraints on that, or at least there should be. A lot of times, pro se defendants think, I'm just going to tell the story and everybody will just hear it and they'll just believe me and everything will be roses. And very, very rarely is that the case. And they note here that Williams' fourth attorney, Ilya Berenstein, will serve as a so-called elbow counsel. If you elbow counsel, slip somebody a note, or you tell them, hey, object to this, or whatever else, maybe they'll listen to you, maybe they won't. They haven't listened so far, so it's, elbow counsel is there just in case. But it's up to the person as whether or not they're actually going to listen. If Monday was any indication, Williams will find representing himself as difficult as it is for the average pro se defendant. His contention that he didn't have adequate time to review evidence didn't fly. So we're talking about that motions hearing where everything was denied. He said 4 attorneys who have had access to this evidence and who, I would presume, knowing the reputations of each, have gone over this with him in detail, probably provided him with copies of whatever they could, Bird said. Bird said Greer is not going to put up with a lot of nonsense and will likely be as demanding of Mr. Williams as he would be a licensed attorney in his court. Bird said Greer must look out not for just Williams' rights, but those of the federal prosecutors who also deserve a fair trial. Just because Sean Williams either doesn't understand or doesn't want to abide by various elements of process, if I were a betting man, I would bet heavily that the process will not be compromised because that would put the government in a worse position. Bird said all of the attorneys who represented Williams have good reputations. He said Mr. Williams' apparent decision to formally file a written complaint to the state bar against Joseph McAfee, attorney number 3, was telling. It might be 1 out of 100 that you get where somebody is just so bent on this reality they've created for themselves that they keep getting an answer that they don't want to hear. Our job as attorneys is not to give you the answer that you want to hear. It's to tell you what you need to know, like, this is how this is going to go. This is how the evidence is going to be used. This is what we're up against. Some people can handle that, but every once in a while, some can't. And again, this was July 22nd. And so the next day, Day 1, July 23rd, we get jury selection, and at the end of the day, we already get opening statements. What's the headline of trial day 1? Williams admits to escaping from van in day 1 of trial. And again, we don't have an inside peek. The transcripts, it just said not available. So we're going to read from the reporters. Shout out to Jeff Keeling. Sean Williams' long-delayed first federal criminal trial got off to a slow but contentious start Tuesday that included verbal sparring between Williams, who was representing himself, and U.S. District Judge Ronnie Greer. Once opening statements began around 3:30 p.m., the 6-woman, 6-man jury heard the government's claim that Williams not only escaped from a prison transport van last October 18th, but later bragged to a U.S. Marshal about how he managed it. In a move that may have surprised jurors, Williams admitted to escaping from the van that was bringing him to a court hearing in Greenville. I'm not contesting that, Williams said after prosecutor Greg Bowman had described the U.S. government's version of the day in detail during his opening statement. I did do that, Williams said. I'm contesting my lawful custody during that time. So it was okay that I escaped because I don't agree with why I was being held. Williams faces 2 escape-related counts in this trial, including a second for an alleged attempted escape from the Washington County Detention Center, July 23, 2023. He could face up to 5 years in prison on each count if found guilty. And we have a quote here from prosecutor Greg Bowman. All that's left behind is the other inmate and some shackles. So I guess, remember we looked back at this. You guys, we've got tons of videos on this case and how we got here, but it was kind of like a mystery. It's kind of a mystery. And I guess we find out through this opening statement, although opening statements aren't really evidence, that shackles were left behind in the van. Because that wasn't really clear from the reporting in the early days where the shackles were, what happened to them. It was like, did he get them off somehow? Why weren't shackles found anywhere, like if he was on foot trying to run away and got them off at some point? Someone he knocked on the door didn't remember that he was in shackles. But suddenly we have this detail that, at least in opening statements, which might not be evidence, the inmate and some shackles were presumably left behind in the prison van. So I wonder when that detail came about. Interesting. Williams has been in federal custody other than the 5 weeks he was at large in October and November 2023 since early May 2023. He was transferred to federal custody after being arrested in Cullowhee, North Carolina, April 30th, 2023 on drug charges because he had an outstanding federal warrant from 2021. So that's back to Cat Doll, Tennessee, Johnson City, when he was charged with being a felon in possession of ammunition. He spent almost 2 years at large after Johnson City police tried to arrest him on May 5th, 2021. Williams began his own defense just 12 days after Greer allowed Ilya Bernstein, Williams' fourth appointed attorney, to withdraw. Greer had warned Williams repeatedly that he would wind up representing himself if he continued to run into issues with his defense attorneys. Early on, prosecutors revealed that they had offered Williams a plea deal. They would drop the attempted escape count on condition that all investigative materials about either escape case remain inaccessible to Williams. He had turned that down. Wait, so they wanted to offer him a plea deal to avoid discovery? Well, I don't love that. And I'm cautious, I'm hesitant to say anything that would favor Williams, lean in Williams' favor. I don't like that the government is offering a plea deal to somebody with the bargaining chip of avoiding discovery at this point in time. You're asking someone to take a plea deal without knowing what you have against them. So don't love that. I don't love that at all. But Williams turned that down. The trial included bouts of tense exchanges as Williams repeatedly tried to introduce two themes Greer said weren't admissible or relevant. One, that he hadn't had adequate time to prepare, and that alleged corruption by Johnson City Police was relevant to his escape cases. So he's not listening to the judge's instructions on what's not admissible. At one point before jury selection, Williams mentioned having lots of evidence that all that is connected. I have 7 boxes. So bolstering. Each time Greer shut Williams down, often his prosecuting attorneys were also objecting to Williams' statements. So the judge peeped it. He reminded him that both arguments had been ruled irrelevant to his escape cases. Before the jury was even seated, Williams responded to one of Greer's reminders by saying, "Are you involved in this corruption? I don't get the motives here. What are we hiding here?" To the judge. He's saying this to the judge during voir dire. Soon after, Greer told Williams he was not going to engage in a running argument with you. After the jury was finalized, Greer told jurors that Williams was innocent until proven guilty, and that federal prosecutors Bowman and Megan Gomez had to prove several things beyond a reasonable doubt, including 1, that Williams was legitimately in federal custody, 2, that he'd been arrested on a felony charge leading to that custody when each incident occurred, 3, that in the case of the actual escape, he knowingly and voluntarily left custody without permission, 4, that in the attempt case, he committed an overt act that was a substantial step toward leaving custody without permission, and that he knew his actions could result in his leaving without permission. In his fairly brief opening statement, Bowman told jurors Williams' actions undermine the foundations of the U.S. justice system. He said they'd hear witnesses describe the meticulous planning he went through to evade justice. Bowman described how on July 23rd, a Washington County Sheriff's officer, acting on a tip from other inmates that Williams was removing materials along his cell wall, found a section of wall about 4 feet long and 4 inches high that Williams had allegedly removed before hiding his work using toothpaste to reattach the material. Now, this is kind of funny because if it's true that these inmates, they all make these holes and they have to repair them all the time and they're all patchy because they're getting repaired all the time, if it's normal, but this guy was just I don't want Williams coming over here. What if this tip was just yeah, we do this all the time, but just get this Sean Williams guy away. He's trying to get into my cell and I'm not okay with that. So how did we get this tip? Oh man. He also said authorities discovered journals detailing Williams' plans for escaping and for how he intended to survive. Oops. Then Bowman got to the October 18th escape, which drew national attention when an intense multi-day manhunt grew cold. Williams wasn't captured until November 21st, and by then he was in Florida. Bowman said Williams was shackled and belly-chained and riding with another detainee who also had a federal court appearance when he left Laurel County in the back of a van with 2 officers up front. As the van readied to pull into the Greenville federal courthouse, the other inmate starts yelling, Bowman said. So these are new details, guys. These are new details. The officers stopped the van and noticed the backside window was broken out. All that's left is the other inmate and some shackles. The officers stopped the van and noticed the backside window was broken out. All that's left is the other inmate and some shackles, he said. Williams' trail had grown cold until authorities got a tip November 17th that he was in Sylva, North Carolina. They nearly found him there in a truck that had been reported stolen out of Greenville not long before, then used license plate tracking technology to trace the truck to Pinellas County, Florida. A sheriff's officer there saw the truck November 20th, followed it, and allegedly saw Williams get out at a residence, but he wasn't caught until the following day after a tip that he'd been at a convenience store. Bowman said Williams had also kept a journal after his Greenville escape with details of the escape and even pictures of an abandoned house in Greenville where he holed up for about 3 weeks with plenty to survive on. That sharing on paper became verbal when 2 U.S. Marshals picked Williams up in Lewisburg, West Virginia after his return from Florida and drove him to Blount County, Tennessee jail where he has been staying since December. He began to tell them about his escape, Bowman said. He said Williams described how he managed to remove a loose metal clip in the rear of the van and use it to get his handcuffs open before his shackles to pry open the window and leap out of the van as it approached Greenville. Oh my god, they're drilling his outfit. So we're back to tough procedural sledding for Williams. Dressed in a slightly too large black sport jacket and open-necked white dress shirt and out of handcuffs during his defense, Williams ran into numerous objections from Bowman and Gomez as he made his own opening statement. Williams' thick wavy hair was much longer than most of his booking photos. He wore glasses and had a long-ish goatee. Greer often upheld those objections and also again warned Williams after he tried to bring up his lack of prep time and potential police corruption. "You cannot talk over me," a seemingly exasperated Greer said at one point. "You cannot argue with me. If you want to make an opening statement, make it." In the end, Williams' largely meandering statement did hone in on at least one potential argument about the July incident, that he may not have been able to escape since the cell wall simply adjoined another cell. It's a good argument if you ask me. Why would I be carving out to get into another cell? Is that really an escape attempt? So, he also noted that authorities didn't move him to a maximum security cell after the incident. And then the article shows this photo here with the partition being, not very long. The day ended with the prosecution completing its time with one witness and getting halfway through its second. U.S. Marshal Keaton Bostick said he was one of the 2 marshals transporting Williams back to Blount County in December. During cross-examination, Williams asked him whether, as he described his escape, "Did it seem like I was bragging to you?" "Yes," Bostick answered. "Was I crying?" Williams continued. "Yes," Bostick said. "So I was bragging and crying at the same time?" Williams asked. Bostick said Williams was crying later, and when Williams later asked what he had told Bostick about his attempted escape, Bostick, with the help of his report, said, "You didn't talk about the attempted escape." Williams then made one more attempt to bring up alleged police corruption, mumbling about having brought it up in the van with the marshals. Gomez quickly objected and Greer cut him off. "The evidence suggested in your question is irrelevant," he said. "It's inadmissible." The day ended with Williams gaining perhaps his first achievement, as, with the help of Berenstein's advice, he managed to get introduced into evidence a photo of his cell in Washington County and the adjoining cell separated by the wall in question. That was during cross-examination of Washington County Sheriff's Deputy Toby Briggs, who was the corrections officer that searched Williams' cell on July 23rd and discovered the disturbed wall material. Greer ended the trial for the day shortly after 5 p.m., with Williams due to continue his cross-examination of Briggs when the trial resumes at 9 a.m. on Wednesday. All right, so on Wednesday, the next day, prosecution finishes witnesses at Sean Williams' trial. And this is a picture of the van that he escaped from. Prosecutors wrapped up their 2-count escape case against Sean Williams in federal court late Wednesday after an eventful second day that included eyewitness descriptions of Williams' October 18, 2023 escape. The day ended with prosecutors resting their case aside from closing arguments after calling 9 witnesses. Williams' pro se status has created some tension as U.S. District Judge Ronnie Greer's patience occasionally has worn thin when Williams' statements have violated court procedure. "I'll have the marshals gag you, and I'll force Mr. Berenstein to represent you as best as he can." And this was Judge Ronnie Greer's warning on this day that we're reading about now, July 24th. Before the jury even entered the courtroom, things got heated as Williams, aided by elbow counsel Berenstein, sparred with Greer. He argued over timestamps on some evidence photos and claimed that a private investigator who the government is paying to work for Williams wasn't doing his job adequately, especially in finding witnesses for Williams. Greer also warned Williams against bringing up potential corruption by the Johnson City Police Department, a topic the judge has ruled irrelevant to the escape case and therefore inadmissible. Greer said Williams' attempts Tuesday to get a witness to discuss Williams' claims was a game you're playing. Williams interjected numerous times during Greer's various warnings, eventually frustrating the judge to the point of telling Williams, "If he didn't stop interrupting, I'll have the marshals gag you and I'll force Mr. Berenstein to represent you the best he can." So that didn't happen Wednesday, but shortly after the warning, when Williams said he wanted an itemized list of witnesses he sought as he continued complaining about the investigator, Greer delivered another scorcher. Mr. Williams, this is classic narcissistic behavior. Blame everybody else. We're done. We're done on this issue. All right, so we're diagnosing from the bench. Scorching. Parade of witnesses, dual notebooks. On a day that included examination and cross-examination of 7 prosecution witnesses, Williams further made it clear that he admits to escaping from the van October 18th. His only defense on that count, according to Williams' own words, will be that he escaped what he was termed unlawful custody. Williams spent significantly more time cross-examining witnesses who described the Washington County jail incident. He focused on the alleged removal of material in a cell and what that cell was connected to, another cell, but didn't draw out a strong conclusion as he questioned witnesses. As Williams often struggled to frame his questions according to court procedure, Greer actually intervened to help him on numerous occasions. When prosecutors Greg Bowman or Megan Gomez would object, Greer sometimes gently suggested what Williams was trying to ask and had the witness answer that question. Williams raised several interesting questions, including when he got Washington County Sheriff's Officer Toby Briggs to say that despite Williams getting a disciplinary write-up for the alleged escape attempt, no one that Briggs knew of had a copy of the write-up. Because I didn't get written up, Williams said. The write-up doesn't exist. Greer, however, asked why that was even relevant, after which Williams seemed to insinuate Briggs might be perjuring himself, asking Greer once and Briggs once whether Briggs was under oath. Another Washington County witness, jailer Christina Bryant, testified that on a search of one of Williams' cells on July 23rd, she found what appeared to be a copy of the New Testament and Psalms, but actually contained a journal inside. The pages of that journal, which included a booking photo of Williams from a jail face sheet, and the words escaped convict after occupation, contained a great deal of writing seemed related to planning an escape or successfully eluding capture afterward. Bowman went page by page as jurors looked at photos of those pages on computer screens. They saw notes about flooding a cell, ordering a taser, and untraceable burner phones, and interpretations of what appeared to be an alphabetic code the writer had included. Bryant read through several of those, including one that said, quote, "I need to see an aerial view of the jail." Another that read, quote, "Would you pick me up in the cemetery instead?" And another that said, "I can be out for an hour and not be noticed." There were also references to trading for items, including a sewing needle and a sharpening stone, items Bryant testified would be considered contraband inside the jail. All of this that we've gone over was contained within that Bible cover, Bowman asked Bryant, who responded, "Yes, sir." Williams asked a few questions about the journal on cross-examination. He did ask whether anything written in it that she saw would indicate a substantial step toward planning an escape. Prosecutors objected to the question, and Greer sustained their objection. The other reference to a journal came as prosecutors questioned Pinellas County, Florida Sheriff's Deputy Ashley Hughes. Under questioning by Gomez, she testified to finding a journal November 20th, 2023, inside a truck that Williams had allegedly stolen several days earlier in Greenville. Hughes recounted details in the journal that also referenced escape and had significant details about changing appearance, altering the truck's appearance, and concerns about getting money and shelter, among other things. Williams had few questions for Hughes or for Dominic Brissett, the Pinellas County canine officer who described tracking and apprehending Williams November 21st with the help of his dog Voodoo. Nor did he have many for Cody Reed, who was a Laurel County, Kentucky officer who described driving the van that Williams escaped from on October 18th, or for the Tennessee Bureau of Investigation officer Thomas Garrison, who described the long but ultimately successful search for Williams. The state's final witness was FBI Special Agent Paul Durant. Durant told jurors he specialized in investigating crimes against children and had been investigating Williams, who also faces federal CP production charges about 2 years ago. And to be clear, I think this sentence, who also faces federal CP production charges, I don't think that was told to the jury. I think maybe it was. Maybe they found it relevant enough to explain a motive for an escape. But here it only really... I'm not sure what they're saying was told to the jury. That is, it could be a little relevant. Could be relevant to an attempted escape. I wish this was a bit more clear. Durant's testimony centered around a series of recorded outgoing jail calls Williams made from the Blount County Jail March 27th. Excerpts were played for jurors in which Williams can be heard describing his escape from the transport van, with details of how he did it and how he then survived without detection for days in Greenville inside an abandoned house. Williams can be heard describing finding metal clips behind a door panel, removing one, and using it to successfully unlock his handcuffs. This thing was like already a effing key, Williams says. He also describes how he almost jumped out at one point while the van was moving fairly fast, but then waited until Greenville, and says of the two officers in the front of the van, "I don't see how they didn't know it," when he broke out of a window with his shackles. Quote, "God was helping me, that's the best explanation," Williams says before describing the scene after he finally got out and landed on his knees. Quote, "The van just kept on going, never knew that I got out." Williams asked if the entire calls could be played, but Gomez reminded Greer that other sound contained material that had been ruled inadmissible for the jury to consider. Williams had just one question for Durant on cross-examination, asking whether the call included, quote, "mention of an HBO documentary." Prosecutors objected, and Greer sustained the objection. After the jury exited just after 5 p.m., Williams said he would file a motion related to witnesses Thursday morning. He listed more than half a dozen he'd like to call. Greer will hear the motion at 9 a.m. Thursday, and the jury will return to hear the defense witnesses' interviews and cross-examination starting at 9:30. Now, in a separate article, we get some more context from the different witnesses. So Cody Reed, one of the transport guys, this is a Laurel County, Kentucky sheriff who was in the van, and it describes that this transport work is on a contract basis, and about an hour and a half before the scheduled 5 departure, he said he wasn't assigned to drive that day, but a colleague had a new baby and he took his shift. "I got stuck with that transport," Reed said, who said that he transported Williams once before, but knew nothing about his charges, which by then included 3 counts of production of CP, fed the detainees breakfast, and prepped them for travel. "I placed them in shackles," said of Williams, adding that he also placed him on the van. In the van, maybe? He and a partner then got into the front, which is separated from the rest of the van by a half-inch plexiglass divider and a metal cage, and headed down US Highway 25 and through the tunnel at Cumberland Gap. So that's here. Asked if he heard anything from the back during the trip, Reed said that only after passing through the tunnel, Mr. Williams had hollered and said he was not feeling well. He added that he told Williams he'd have to deal with it, but sped up slightly to try to get to Greenville sooner. From there, they drove to Morristown on US 25 before cutting over to Interstate 81, eventually taking the Bulls Gap exit and heading into Greenville from the west. Williams apparently had removed a metal clip from behind a door panel and managed to open his handcuffs many miles earlier, but was still in the van as it slowed on entering Greenville and heading for the courthouse. After waiting for a Washington County vehicle to leave the Sallyport area where inmates are transferred, Reed was readying to pull in when he heard the other inmate yell. "I stopped, jumped out, and checked," Reed said. That's when he discovered Williams wasn't in the van and the back driver's side window was broken out. He said he yelled immediately to U.S. Marshals who were there. Reed said he then searched the back of the van. "We found a pair of handcuffs. I think they, the other searchers, found a pair of chains. Also found was a metal clip and a headrest that had been removed from a seat. The handcuffs were damaged to the point of not being usable," Reed said. Photos of the van showed to the jury included the broken back window, a hinge from the metal cage that had been broken, and the front barrier. Asked about whether he or his partner heard anything, Reed said no and described how the barrier made it very difficult to hear anything in the back. "We had actually told our command staff multiple times, oops, prior to this incident that needed to be fixed," Reed said. Now, a U.S. Marshal, who Williams later allegedly told about this day of the escape, said this is Williams' description being relayed. Williams described quickly getting onto the roof of a building, then climbing down later on October 18th, after the search took to the air. He told the marshal he then found an abandoned house that even included some food he was able to eat. And it turned into a long-term search, and they ended up obtaining some security footage of Williams getting into a truck. It was a Toyota Tacoma made between 1998 and 2000. And then learned that on November 18th, they learned that a similar model had been reported stolen out of Greenville 2 days before on November 16th. Now, one thing that Williams did not do, despite his meticulous planning, was obtain a different license plate to put on the stolen truck. So using flock cameras, which can read license plates, the Tennessee Bureau of Investigation learned that a camera somewhere in Clearwater, Florida, had photographed the truck with its original license plate shortly after noon on November 18th. And then we find out from Pinellas County Sheriff's Deputy Ashley Hughes. She was a young deputy who got word of the bolo, the Be on the Lookout, and decided to look to see if she could get any leads. So she did some research and learned that Williams' father had once owned a house in Seminole, Florida. So she ends up going with another deputy to drive by the location, but doesn't see the truck. But while they're driving on the thoroughfare, she sees a truck that looks similar, and then notices that the tag isn't from Florida. So she decides that it's Williams and thinks that Williams took a couple of turns that may have been evasive if he had seen her car, but she eventually saw him pull into a driveway. So then using binoculars, she confirmed the license plate and that she saw a man get out but wasn't sure if it was Williams or whether it was a resident of the home. It wasn't, and the homeowners actually called and said a man had walked up to the door and dropped a duffel bag. They let Hughes, who never saw Williams return to the truck, watch their doorbell camera video, which she later saved. Jurors were able to see a video showing a man walk up to the front door and drop a bag. Hughes said she processed the truck before her shift ended at 6 a.m. November 21st, but that she came back on at 6 p.m. that night and kept researching based on information from a journal she found in the truck. It included a reference to safe places that included 7-Eleven. I started going to every 7-Eleven in the area and spreading the word, showing pictures of him, Hughes said. A clerk at one 7-Eleven store later called to say he thought Williams was there. Hughes immediately went there, but Williams had just left. She watched some store video and saw what looked like the same person she'd seen the previous night, so she made some radio call for officers to set up a full search perimeter. Then we get the canine and Voodoo's on it. Oh, and then Voodoo briefly loses the trail. And then we get on widening circles until we regain the scent. Soon he gave a proximity alert between the two houses, Brissette said, describing that as Voodoo getting frantic and wagging his tail as he does when he is very close to a subject. Brissette noticed a covered porch with a lot of items on it and thought Williams might be in there, but the dog alerted to a fence jump, then leapt over a fence. Brissette said he followed, heading north between the fence and a house, and turned off his flashlight. We came up on a tarp, the dog nudged it to the side, and I saw the suspect, Brissette said. After a brief struggle, officers arrested Williams, who was wearing the same clothes from the home doorbell video of the previous night. Brissette said he then saw Williams' face and was able to make a positive identification. Sean Williams had eluded authorities for 35 days, far longer than the norm for an escaped inmate. Offered a chance to cross-examine Brissette, Williams declined, but when Brissette identified him from across the courtroom for jurors, Williams offered a wave back to him that looked like a sign of respect as much as anything. Williams' trial resumes at 9:30 a.m. Thursday, when he's expected to call his first of multiple witnesses. Alright, so hearing the story of Voodoo is kind of cool. It's kind of cool to hear. Alright, so now we're going to get into day 3. We're going to get into day 3. So we're on Thursday, and this is, again, a report from the end of the day. So by the end of this day, day 3, both sides are done with witnesses, and closing arguments are set for 9 a.m. on Friday. By the time he finished interviewing witnesses on the trial's 3rd day, it was clear that Williams, who also faces multiple S-related charges, was convinced he wasn't getting a fair shake. Quote, "If you're going to handicap me in this way, I'll just wait for an appeal." Williams told U.S. District Judge Gronny Greer at one point late Thursday after being told he likely couldn't have a week's delay to try to find more witnesses. Shortly before, during what was 30 minutes of mostly monologue from Williams with the jury not present, Greer had reminded the defendant he'd had 10 days to try to find former Washington County Detention Center inmates he said are critical to his defense. He's made no effort to find them, Greer said. No effort. Those type of exchanges were par for the course in a day that belonged to Williams, as prosecutors Greg Bowman and Megan Gomez had finished calling witnesses Wednesday afternoon. In between Williams interviewing 5 witnesses, he complained that a private investigator hired for his defense wasn't doing his job, accused witnesses of providing contradictory testimony, called for a mistrial over a minor technology issue, and appeared to repeatedly frustrate Greer and prosecutors. "I'm being railroaded," he said at one point. "Is this a fair trial?" at another. As he interviewed her, Williams repeatedly questioned Washington County Sheriff's Office's Jessica Smith, that's who put the incident report together for the July 23, 2023 attempted escape, about timestamps on a report. Greer's apparent determination to give Williams as much leeway as possible due to his ignorance of the law came through after a comment from Bowman. "He's just being argumentative at this point, Judge," Bowman said. "He is, but I just don't know how to control it, Mr. Bowman," Greer responded. Greer was at times patient and helping and coaxing Williams to ask questions the proper way, at other times stern, and once or twice clearly angry on a day that he opened by telling Williams, "Please don't talk over me today." Williams was interviewing his second witness, a man named Dustin Aminetti, who had been incarcerated with him at the time he allegedly tried to escape, when he began leading the witness. Remember, this is his case in chief, so this is direct testimony, shouldn't be leading. "Ask a question, Mr. Williams," Greer said. "I'm losing patience with you." Before lunch had even arrived, Williams complained that Greer was trying to muzzle him. "I'm not making any effort to keep you quiet," Greer responded. "You've talked over me again and again." The Pop-Tart defense and the journal response. Williams, who admitted to escaping from the van on October 18th, focused most of his efforts Thursday on trying to show he wasn't really attempting to escape from Washington County Jail, where he was being held as a federal detainee. He spent exhaustive amounts of time questioning the private investigator, Stephen St. John, the inmate, Dustin Aminetti, and 2 jail officials about the walls inside his and adjoining cells. He made 2 more people draw diagrams of the inside of cells a day after requiring the same of his first 2 witnesses. It was all part of what seemed to be Williams' main point. Material he had removed at the very bottom of a wall between 2 cells wasn't related to an attempt escape, but was a common tactic used for inmates to pass commissary items between cells. Aminetti confirmed under questioning that most cells have cracking at the bottom that's often repaired with an easy-to-remove caulk, and also that the resulting gaps tend to be very small. It's only a couple inches, he said. I mean, you could barely get a Pop-Tart under it. Williams said it was just for such purpose that any inmate would remove small footing material at the bottom of a wall, particularly when those walls don't open to any greater chance at escape. Aminetti generally concurred. Just before cross-examination from Gomez, though, Aminetti responded to a question from Williams by saying, "I think you had showed me one time a journal you had written in. It was to that journal, which also came up in Wednesday's prosecution case, that Gomez turned in her short cross-examination of Aminetti. She asked whether Aminetti remembered anything from the journal, which officers say was found later on July 23, 2023, when Williams had been moved to a different cell. He said he remembered some reference to aerial photos of the area surrounding the jail. I also remember a code that was used to communicate with someone else," Aminetti said. He said that Williams told him it was for communicating with someone outside the jail. Bowman also brought up the journal as he cross-examined Smith in the afternoon. She had completed a 19-page report on Williams on July 23rd and photographed a number of the pages in his journal, which had multiple references to escaping. Under questioning, she described the list with checked-off items, including a page that had 3 columns: problems, solutions, and bring. One example included dogs scent, oops, as a problem, coffee, pepper as solutions, and coffee under bring. Another paper had a plan listed, a drawing of a cell, and a drawing of what looked like the outside layout of the jail. As Williams began interjecting to Smith's answers about the journal, Bowman said of the report, "This is straight from an exhibit you just entered," as it was Williams who had asked that Smith's report be entered as evidence. See, this is the difference. Would an attorney, I'm not saying that an attorney wouldn't make this mistake, but would a thoughtful, experienced, focused attorney make this mistake? Probably not. Probably not. End of the road draws near. Even Williams seemed to tire of the trial's duration at the end of Thursday. This is like a 3-day trial and they're tired of it. Spending just a few minutes questioning the 5th Washington County Jail employee to be interviewed. Prosecutors generally spent little time cross-examining, except when they appeared to have a real opening, such as Bowman's interview with Smith. Other times, they seemed ready to get things done, even if it meant conceding something minor to Williams. Around 2:30 p.m., Bowman said he could object to Williams' attempt to enter something into evidence, but added, "If this moves things along, fine." Like, just go with it. Jurors who were shuttled in and out of the courtroom multiple times as Greer, Williams, and attorneys conferenced or debated matters they weren't eligible to hear should get their chance at rendering a verdict by sometime Friday morning. Greer will hear any concerns Williams has about his charge to the jury, so like instructions, and then closing arguments should start around 9. So there's that. I mean, great little peek at something that, if he wasn't pro se, some of this might have gone differently on day 3. This is a pro se defendant presenting his case in chief. Very interesting about the notes about avoiding the dog scent. And I'm wondering, these communications, this journal, how relevant is this going to be in other actions? Who's this person he's communicating with? Allegedly communicating with? He's got this alphabet code. Who's he speaking to? Who's bringing him coffee? It'll be interesting to see when the other cases move along. And remember, part of that plea was, hey, if you take a plea, because there was a plea deal offered with the term of, we don't need to provide you our investigative materials if you take this plea. So my bet is something is very important for the other case, the other prosecution, and maybe part of what they think is so important and don't want prep time for, even though they'll have to disclose it anyway, might be some of this stuff, might be some of these journal entries. All right, so now on Friday, jurors began deliberating Friday morning in the Stroughton Williams federal escape trial. Closing arguments concluded Friday just before 10 a.m. Shortly afterward, the jury was released to begin deliberation, and we get a same-day verdict. So, a jury delivered a split verdict in former Johnson City business owner Sean Williams' federal trial on 2 escape-related counts in U.S. District Court on Friday. Jurors pronounced Williams not guilty of the alleged attempted escape from the detention center on July 23, 2023, and then guilty on the separate count of escape from the prison van on October 18, 2023. Williams faces a maximum of 5 years imprisonment. And David Jolly, we've heard about him. We've looked at some of his statements and concerns about how he escaped from the van in the first place. Jolly expressed pleasure at the result. I'm very pleased that Williams was found guilty of the escape from Laurel County Corrections transport van. Deputy U.S. Marshals and a number of other law enforcement officers did great work and spent a lot of hours working to get him back into custody. And then sentencing is currently set for November 18th. And we get some additional context in this article about closing arguments. So prosecutor Greg Bowman tried to press home that multiple parts of Williams' journal should be acceptable proof that he took at least one substantial step towards escaping. He argued that Williams had checked off items that could be argued as preparing for an escape. He was caught relatively early in his escape, Bowman said. Even so, he had done numerous things, checked off in his journal as he went. There are multiple substantial steps toward his attempt to escape. Williams suggested any such arguments weren't enough. He had said Thursday the journals were nothing more than an example of him exercising his right to free speech. Quote, hopes, dreams, lists about codes, and a Jolly Rancher does not make a substantial step, nor does passing Pop-Tarts cell to cell, he said. Williams was referencing various elements of the recovered journal that prosecutors had tried to paint as sufficient evidence to convict. The journal had included entries from Williams about plans to escape, how to stay at large afterward, and how to communicate with people outside of the jail using a code. After deliberating for roughly 90 minutes, the jury took Williams' side in that argument. Let me also give this detail that Williams told jurors, why he put so much effort into this one relatively petty charge. Because remember, he wasn't really fighting the prison van escape. But Williams made repeat assertions and gave hints that he has somehow been the victim of retaliation for helping expose alleged corruption in the Johnson City Police Department. That claim is also at the root of a civil lawsuit filed a year ago against the city of Johnson City on behalf of multiple alleged R-word victims of Williams. And again, we're not going to see that trial until spring of 2025. But Williams said, I've been singled out for a reason, referencing the fact that he was even charged with attempted escape at a jail less than 10 miles from Johnson City. Mr. Bowman is probably sitting on the edge of his seat waiting to pounce, and in parentheses here, on the inadmissible comments. In fact, prosecutors had offered Williams a plea deal in which they would have dropped the attempted escape account. He rejected it based on their condition that he not be allowed to access any investigative material from either case, including those normally subject to the Freedom of Information Act. He didn't get that far, but said that his efforts to fight a charge the state had offered to drop came because I believe in principle. And here's a reminder, we've talked about it in other videos. While several federal civil cases are pending against Johnson City that relate to Williams, the alleged victim's case has revealed that at least one point, the U.S. government had begun investigating allegations of public corruption at the JCPD. The status of that investigation, including whether it has concluded, has not been made public. And to round that out, we have some analysis from the same defense attorney, Chris Bird, now that the verdict had been rendered. Chris Bird said that the case for the attempted escape did not appear to be especially strong. It's not terribly surprising in that case that he was found not guilty on. It was a relatively weak case. The federal authorities had offered him a plea. I think where they were going to dismiss that, they knew it was a weak case too, but they weren't going to give him anything on that. And I really appreciate, this is Murray Lee and Jeff Keeling, this is WJHL, News Channel 11. They're reminding us about this plea term. We'll give you a plea deal, but you'll be barred from accessing all investigative materials pertaining to both the successful escape and the attempted escape. And so remember, sentencing for this is for November 18th, and the federal trial, the next federal trial that we're looking at for these CP crimes, CP production, it's now been moved to November. So November is the next big date for the happenings in this Sean Williams story. And I'm going to do another video between then and now to catch up on some of the back and forth motions in the civil cases. And we're also going to look at Sean Williams' Facebook posts because they're kind of relevant. They're a little bit relevant to evidentiary issues, really, in civil and criminal actions. But what do you guys think about all of this? What do you think about reading this context of Sean Williams representing himself pro se? What do you think about the notion that, maybe JCPD is dropping the ball? Is it just an excuse from Williams? Can it be a little bit of both? And this is all, we haven't seen all the discovery. A lot of stuff from this case, this escape case, is filed under seal. I can't open it, can't access it. And because it's a federal case, there's no cameras in the courtroom. There's a tight lid on it anyway. But I've got like this lingering feeling, this is myself, like, it's such a priority for this prosecution to not want to hand over investigative materials. And while I don't foresee a future of how Williams can fight the charges he's facing if they have the evidence they say they have, these thumb drives with the pictures found in his possession, the idea that they wanted to offer him a plea deal with the term of not having to turn over materials is just making me think back to Kateri Dahl's alleged experience as she tried to pursue a broader search warrant against this man. She felt like women were at risk because of this man. And her bosses, that lawsuit's still ongoing, so we're going to have to see how it plays out. Her bosses with the JCPD wanted to tailor it down. Didn't really want to look into that. So a ton of food for thought here. Let me know your thoughts. I'm turning the floor over to you guys, and we'll get together. See you guys next time for an in-between before we get to that November, sentencing, and maybe if the trial actually starts in November and doesn't get moved again, we'll be covering some of that. And also in the description will be a link to a playlist of all the previous parts of the Sean Williams story videos that we've done so far. So that being said, floor is yours, you guys. You guys let me know what you think. Bye!